Good evening, everyone. Welcome to Stockton University's Constitution Day keynote address with Mary McCord. My name is Alyssa from the William J. Hughes Center for Public Policy here at Stockton. The Hughes Center is proud to sponsor this annual event and to work alongside the many people who make this program possible. I want to extend a special thank you to the Constitution Day Planning Committee, made up of dedicated faculty and staff, led by co-chairs Dr. Claire Abernathy and Dr. Tina Zappilli. We are also grateful to the Constitution Day Fellows, who are Stockton students dedicating their time and talent to this effort, and to all our Stockton colleagues who supported this event. For nearly 2 decades, Stockton has commemorated the signing of the United States Constitution with a keynote address each fall featuring prominent legal scholars, practitioners, or journalists. Each year, we gather to reflect on the enduring principles of our Constitution and to examine some of the challenges facing our democracy. Because democracy is not a spectator sport. It endures only when citizens remain watchful and engaged. Constitution Day is not just about celebrating this founding document. It involves asking questions, holding institutions accountable, and renewing our commitment to the ideals in our Constitution. In that spirit of civic discourse, you will get the opportunity to engage and ask questions tonight. The last 30 minutes of this program will be a Q&A session with Professor McCord. The QR codes displayed on either side of me will be shown throughout the night for you to scan with your phone to submit your questions. We're so glad you're here to be part of this important conversation. And now it is my pleasure to welcome Stockton University's president, Dr. Joe Bertolino, to the stage to introduce our speaker.
Thank you, everyone. Good evening. Well, I'm Joe Bertolino, president of the university. Delighted that you could be with us to celebrate Stockton University's annual Constitution Day. This event reminds us of the importance of civic education, civil discourse, and coming together with an open mind, sharing with a shared commitment to learning. I want to thank you for being here as we honor a document that, while written centuries ago, continues to shape our nation, challenge our assumptions, and guide our democracy forward. We're gathered just 55 miles from where it all began, Independence Hall in Philadelphia, where on September 17th, 1787, a group of delegates signed the United States Constitution. That moment marked the start of a grand and still unfinished project, the effort to form a more perfect union. Since 2006, Stockton has proudly hosted Constitution Day programs like this one. And while it began as a federal requirement, let's be clear, we're here tonight not because we have to be, but quite frankly, because it matters. And if we all haven't been paying attention as of late, it really, really matters. At Stockton, this is about community. It's about care. It's about nurturing the kind of informed, engaged citizenry that strengthens not just our campus, but our country. Tonight, we're honored to welcome Mary McCord. Ms. McCord is the Executive Director of the Institute for Constitutional Advocacy and Protection at Georgetown Law. She's led groundbreaking litigation to defend constitutional rights and safeguard democracy across the nation. A former acting Assistant Attorney General for National Security, she also served for nearly 2 decades as an Assistant U.S. Attorney. Her work sits at the intersection of law, national security, and civil rights. And tonight, she'll guide us through a timely and urgent topic: executive overreach and the U.S. Constitution. We live in a time when questions of power, like who holds it, how it's exercised, and how it's challenged, are front and center. The Constitution's checks and balances have carried this country through seasons of prosperity and through storms of crisis and division. That's why events like this matter, because learning doesn't only happen in the classroom. It happens when we come together across differences to reflect, to listen, to engage with the systems that shape our lives. That's what it means when we say Stockton is a community of opportunity, a place where we lift each other up, stay steady through change, and believe that learning, empathy, and civil discourse still have a vital role to play in our democracy. We don't adapt our values to fit the moment. We stand by them, always. And among these values is our ethic of care. You've heard me say it many times. Dignity, respect, kindness, compassion, and civility. Dignity, respect, kindness, compassion, and civility. These are the principles that carry us through challenging conversations. They help us grow, and they guide how we lead through an ethic of care. In today's charged political climate, that ethic of care is more important than ever. We've seen moments of political violence that remind us just how fragile and essential our democratic norms truly are. So tonight, I encourage you to bring your full curiosity. Listen closely. Ask good questions. And remember, the Constitution is not a relic. It is a living framework, and each of us has a role in how it continues to serve our democracy. Civil discourse matters, and at Stockton, it is my hope that we are creating a community of opportunity that supports and encourages civil discourse, listening, learning, and understanding one's neighbor, whether you agree with them or not. So, to Mary McCord, I want to thank you for your leadership, your service, and your deep commitment to justice and equity. Your voice matters, and we are grateful that you are here. And to everyone joining us tonight, thank you for investing in your education, your community, and the values that bind us together. And, of course, I can't leave the stage with, as always, soar higher, go Ospreys. Thank you very, very much. Please help me welcome Mary McCord.
That was a very nice introduction. Thank you so much, and thank you so much for inviting me to be here today. Pardon me while I get out my laptop. Those of you who've maybe heard me speak before, maybe you listen to the podcast I do, you know that I usually speak extemporaneously. But when you speak for this long, I want to at least have a few notes up so that I don't lose my track. And also because I'm going to be quoting from the Constitution a time or two and quoting from Supreme Court rulings that have to do with the Constitution. As the president just said, I'm going to be talking about executive overreach, and specifically with respect to the erosion of the rule of law. And rule of law is something that I really want to talk about tonight. I've been trying to work it into almost everything that I talk about these days. Stanford law professor Diego Zambrano recently wrote an essay noting about how Americans don't generally speak about the rule of law, or at least we didn't until recently. And I had the privilege just an hour and a half ago of meeting with a couple of classes of students here at Stockton. I started by asking them, like, do you know what I mean when I say rule of law? And I got a very good response, but when I said, do you know what due process of law is, I got almost every hand up. Because we tend to think in America about due process, that's about our individual rights and liberties, that the government cannot deprive us of without due process of law, without a notice and an opportunity to be heard before they take property, our liberty, etc. It's very individualized, particularized. Whereas those who live in post-authoritarian states in particular, they view the rule of law as what stands between democracy and dictatorship. Indeed, I've written about due process of law several times. It's the one thing that is so fundamental that all 9 justices of the Supreme Court, who don't that often all 9 agree on anything, all 9 agreed earlier this year that it was that for the administration to attempt to spirit away, not attempt, it actually did, spirit away on airplanes Venezuelans accused of being members of Tren de Aragua without any notice or opportunity to contest their removal before their removal violated due process of law. This was after the president signed a proclamation under the Alien Enemies Act that declared that Tren de Aragua, this is a drug cartel in Venezuela, it was recently designated a foreign terrorist organization by the president, determined that Tren de Aragua was acting at the behest of and the direction of the Venezuelan government, therefore was almost a proxy for the government, and that Tren de Aragua was engaging in an invasion or predatory incursion into the United States, and therefore under the Alien Enemies Act could be removed from the United States. Now, the Alien Enemies Act has only been ever used 3 times before, and it was all in a declared war. And it is something that's even controversial then, but it involved a declared war. We, of course, don't have a declared war. So the issue there was, do they get an opportunity before they are removed to a terrorist detention center in El Salvador, not even their country of origin, do they get an opportunity to go to the courts and say, 1, I'm not a member of Tren de Aragua, if that's the case, and 2, at any rate, Tren de Aragua is not an arm of the Venezuelan government and is not engaged in an invasion or predatory incursion into the United States. And that's where all 9 justices agreed, right? No matter what we may think about that drug cartel, matter what we may think about whether the Maduro regime in Venezuela is actually trying to infiltrate this country, the point is these people were entitled to due process. But as Professor Zambrano from Stanford has pointed out, it's the luxury of living in a country that has largely avoided systemic threats to democratic institutions that has allowed us to focus on individual due process rights like that. But that is not the case any longer, because the pillars of our democratic foundation are being eroded, the pillars of the rule of law. We can't just afford to focus on individual rights and due process under the assumption that our institutions of governance, right, the legislature, the judiciary, the executive, will hold, will endure. We need to think about that bigger picture. We need to think about what people in post-authoritarian regimes in Latin America and Eastern Europe, what they think about. We need to be thinking about the rule of law. Okay, so what do I mean? That's a long wind-up to something I haven't defined. There are different definitions out there, but I think they all take the same frame with 4 pillars. The first is a system of laws by which both the governed and the government agree to abide. The second is transparency in the enactment and the enforcement of that law so that we have predictability and stability. Third is a fair legal system by which rights and responsibilities are evenly adjudicated. And fourth and finally, diverse, competent, independent lawyers and judges. So due process is a foundational part of that rule of law, but the rule of law is broader, it's institutional, and it's what's under attack right now due to executive overreach. If we fail at preserving the rule of law, then due process is a nicety that will no longer be accessible. Today we're witnessing attacks on all 4 pillars of the rule of law, and I want to talk about these and break them down. Let's start with the first, a system of laws by which both the governed and the government agree to abide. So we're talking about the Constitution, right? That binds all of us, including the government. Let's just talk about day one, January 20th of the current administration. On day one, the president signed an executive order that purported to reinterpret the 14th Amendment's citizenship clause, the 14th Amendment of the US Constitution. Let me read you that clause. It says, and I think you were given handy-dandy little pocket constitutions when you came in. I will note, I have one in my backpack at all times. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. But what the president tried to do by executive order was reinterpret what those words mean. And what he said in that executive order is that going forward, a person will not be a citizen if they're born here in the territory of the United States, even though they're subject to our laws, if they don't have at least one parent that is either a citizen or a lawful permanent resident, meaning having a green card. Now, so this means not only would the children of undocumented persons no longer be citizens, but even the children of people who are here lawfully but temporarily, so on student visas, on work visas, on temporary protected status, with active asylum proceedings and work permits. These people sometimes are here for decades. They make their families here. They are part of communities here. They buy homes here, but their children would not be citizens. Now, this executive order was immediately litigated. In fact, my organization was one who brought a case on the very first day and won in court less than 2 weeks later, with a judge saying in court the very day we argued that this executive order violates the text of the Constitution, binding Supreme Court precedent that's more than 125 years old that recognized citizenship by birth on jus soli, the soil of the United States, and our history since the founding of recognizing citizenship by birth. Now, it could be that policymakers, it could be some of you in this room, think that that's a bad idea, a bad policy. Maybe we should have a different policy. But you don't get, as the president, to just reinterpret an amendment to the Constitution. I mean, you know he can't do it by changing a policy because it's an amendment, and an amendment can't change, and a policy can't change an amendment. But reinterpreting it, let's think about for a minute, what would that mean? And I was very proud of one of the students today who asked me this very question. How could it be that this would only apply going forward if we're reinterpreting the Constitution? How many of you in this room, yourselves or somebody you know, was the child of people who were here on work visas or student visas or some other temporary status? It would be a lot of people in the United States of America who, based on this reinterpretation, would not be citizens. And to say that only applies going forward, well, that's something the government is arguing now, I think, to make this all seem a little bit more palatable. But if it's a reinterpretation, then that's what the 14th Amendment means. Now, this is just one example, but I think it's a prominent one that we can all relate to of how this executive branch has really gone beyond what the Constitution permits in derogation of the Constitution and in disregard for its amendments. But there are other examples as well. The president, through the Department of Government Efficiency, remember this, DOGE and Elon Musk, has dismantled government departments and agencies, fired scores of government employees, impounded funds appropriated by Congress, and what I mean by that is refused to spend funds that Congress specifically appropriated for specific purposes. But that's not the president's constitutional authority. It's Congress, not the president, that has the constitutional authority to create departments and agencies. Yes, the president has a responsibility in the Constitution for executing the law of the executive branch, but it's Congress that creates those departments and agencies. That didn't happen by the president designating them. That happened by Congress. And it's Congress, not the president, that has the power of the purse, right? To appropriate funds for those departments and agencies, for the policies and programs that they implement and that they enforce. And when Congress says that's what this money is to be used for, The executive does not have the constitutional authority to just say, no, I'm not going to do it. I don't want to do it. That's a separate body of three equal branches of government, the Congress, and their authority is where, it's written right up here on this excerpt on the screen, right? The legislative authority belonging to the Congress. But that's not all. The president also fired appointees to bipartisan boards of independent agencies created by Congress. So what am I talking about? I'm talking about things like the National Labor Relations Board, the Consumer Finance Protection Board, the Federal Trade Commission, and now even the Board of Governors of the Federal Reserve that sets monetary policy for this country that has impacts across the world. These were independent agencies created by Congress with bipartisan appointed boards given lengthy terms so that each term would extend beyond any particular president. There had to be bipartisanship, so presidents of both parties over the course of time appointing these board members, and removable only for cause. But this precedent has said, I'm not going to pay attention to what Congress said. I'm going to remove those members of these boards who were appointed by Democratic presidents, and I'm just going to defy not only what the Constitution says, but what 90 years of Supreme Court precedent says. Now, we have cases up in the Supreme Court, including involving the purported attempted firing of one of the members of the Federal Reserve Board, asking the Supreme Court to overturn that 90-year-old precedent and say that to the president, you can fire whomever you want, regardless of what Congress has said. We've also had the president impose enormous tariffs, I'm sure you've heard about these, on all kinds of goods without statutory authority. Now, there are some tariffs that Congress has created a statutory system for that the president can then oppose. But this is a different category where the Congress has given no authority to the president to impose tariffs. And these have been some of the biggest ones we've seen, the 50%, the 35%, in some cases 100% tariffs. No lawful authority at all because it is Congress, not the president, that has the power to lay and collect taxes. That case is also going to be heard in the Supreme Court this fall. We have the president through the Department of Homeland Security, who, as I already mentioned, has deported Venezuelans and other immigrants without due process, and has even tried to remove unaccompanied minor children literally in the dark of night on Labor Day weekend, the Sunday morning of Labor Day weekend, from this country back to their home countries with no notice, no due process, no opportunity to be heard. And the president now, and you've all probably been watching news this weekend, although this also happened elsewhere a couple of months ago, has sent the military and National Guard into our cities, despite the fundamental premise of the Constitution established by the founders, by congressional enactments, by the 10th Amendment, that strictly limits the use of the military for domestic law enforcement. So at the core of all of these examples is a violation of the separation of powers principles that is at the heart of the Constitution. Now, it's true, there's no words in the Constitution that say there shall be separation of powers. But you can read all the history of the founders and you can just see it the way it is baked in. That's why we have 3 equal branches of government. They occupy the first article, the second article, the third article. The first article is the legislative power in Congress. The second is the executive power in the president. The third is the judicial power in the judiciary. And these powers are, in some cases, overlapping, and that is very much by design. So, for example, Article 2, the president is the commander-in-chief of the military. But under Article 1, it is only Congress that can call forth the militia, can declare war. Under Article 1, Congress has the power to enact legislation, but under Article 2, the president is tasked with executing the legislation enacted by Congress. And the judiciary has the power to say what the law is. So this has led to compromise over the decades, that push-pull of checks and balances that relies on those in each branch to have respect for the authority of the other branch and actually want our institutions to endure. So there have been times when we have had what could have very well been a constitutional crisis, when two branches are trying to assert authority and compromise is reached, because historically, the people in those branches wanted to see our system survive. When one branch overreaches, another can act to check that overreach. So if the president issues an executive order that Congress thinks is outside the president's authority, one thing they might do is conduct oversight hearings, have members of the executive branch come in and ask questions and answer questions. They can pass legislation to rein back in that executive authority. Or they can even sue. Congress can go to court and sue and say, President, you're exceeding your authority. If the judiciary issues a ruling interpreting a federal statute as meaning a certain thing, and Congress says, no, that's not what we meant at all, that's not the interpretation we intended, they can pass a new statute that overrules that judicial interpretation. If the judiciary finds a statute or an executive action, an executive order, to be unconstitutional, it can strike it down. So we have ways, right? That's the checks and balances that is the necessary analog to separation of powers. But today, despite Congress having the authority to make the laws under Article 1, its laws are being ignored. And despite the judiciary having the authority to say what the law is, that is to interpret the Constitution, its rulings are, at least in some cases, particularly in the lower courts, being ignored. And the executive has been empowered by a 2024 decision by the US Supreme Court that has produced long-lasting consequences. And that's the immunity decision. Sorry, I should have gotten this open before I started. So I testified before the Senate Judiciary Committee last September 2024 about the immunity decision in the case of Trump versus the United States. The only issue that was before the Supreme Court in that case was whether Donald Trump, as a former president at the time, was immune from criminal prosecution for his efforts to overturn the results of the 2020 election. He had been indicted for violating 4 different criminal laws: conspiracy to defraud the United States by obstructing the federal government's role in certifying the election, conspiracy to obstruct, and separately obstruction of the constitutionally required joint meeting of Congress on January 6th to count the electoral ballots from the states, and conspiracy to deprive citizens of the right to vote and to have their vote counted. So the court could have looked at the question in front of it as narrowly as, does an allegation of the president violating these laws, is that something for which he could be immune from criminal prosecution? Or should he, like all of the rest of us, be held accountable under those laws? But when the Supreme Court granted certiorari, that's the process of saying, we'll take this case, we'll hear this case, it announced its intent to decide a question that was much broader than the narrow question presented in the case. And here's the question that it said it wanted the parties to address. Whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Right, so it wasn't, let's look at the particular facts here and whether they violated a particular crime and decide whether that is something for which he should be immune. It's like, let's decide this broader question. And indeed, writing a, quote, rule for the ages, as Justice Gorsuch said during oral argument, the majority answered its own very expansive question by declaring first that presidents are absolutely immune from exercising core constitutional powers, and then at least presumptively immune for other official acts. Now, I could go on and on about how it defined official acts and the fact that it didn't actually then answer the real questions in that case about the things that the president was alleged and indicted for doing. They wanted to make a broader statement. And what the court then did is it went on to define what core constitutional powers are for which the president is absolutely immune. It defined core constitutional powers capaciously, far beyond the powers you will find if you look at those pocket constitutions. The Constitution explicitly gives sole discretion to the president for things like pardoning people. That is totally up to him. Vetoing legislation, totally up to him. recognizing foreign governments. Those things are in the Constitution. But no, the Supreme Court went farther. It added to that list of things that were explicit in the Constitution the president's just responsibility for the actions of the executive branch. So it included within core constitutional powers the president directing the Department of Justice to launch investigations into election fraud, and even said that would include sham investigations, that's the Supreme Court talking, and to pressure states to replace their legitimate electors with fraudulent electors. Because the Department of Justice is an executive branch, the court concluded the president has that power to direct it to do things, and the president cannot be held accountable, at least criminally, for things that might otherwise be violations of law. For these exercises of core constitutional power, the Supreme Court held that the president's authority is both conclusive and preclusive. Conclusive meaning that Congress can't act upon it to limit it, and preclusive meaning the courts can't review it. Now, the majority relied on Justice Robert Jackson's concurring opinion in a 1952 Supreme Court case called Youngstown Sheet and Tube Company versus Sawyer for this phrase. How many people in here know about that case? Yeah, a few. It's been talked about a lot lately, and it's been cited in many opinions. But it's worth a pause here to consider the facts of that case. So this case arose after President Truman ordered the Secretary of Commerce to seize and operate the steel mills in most of the country after the United Steelworkers of America announced a nationwide strike. Now, President Truman believed that the work stoppage that would come from that strike would immediately jeopardize the national defense because of the indispensability of steel to producing weapons. The Supreme Court held that the president's order was not authorized by the Constitution or by an act of Congress, which were the only possible two sources of power that he could use to take over the steel mills. The court majority rejected the president's argument that although there was no explicit constitutional provision granting the president this power, it could be implied from the aggregate powers under the Constitution. The court in that case said that President Truman's order could not be sustained as an exercise of his power as a commander-in-chief of the armed forces, because whatever power he might have in the theater of war, it did not extend to seizing private property in order to keep a labor dispute from stopping production. The court also said that was a job, the court said, for the nation's lawmakers, for Congress, not for military authorities, even if they're the president's military authorities. The court also said that the President Truman's order could not be sustained based on the constitutional provision that grants the executive power to the president, the same provisions that essentially this majority in the immunity case was relying on. It said, under our Constitution, the court said, the president's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. The Constitution limits his functions in the lawmaking process to the recommending of laws he thinks are wise and the vetoing of laws he thinks bad. And the Constitution is neither silent nor equivocal about who shall make laws which the president is to execute. The court further explained, referring directly to Article 1, that begins, the first section of the first article says that all legislative powers herein granted shall be vested in a Congress of the United States. The court then explained that after the Constitution in Article 1 lists a whole bunch of powers of Congress, it comes back to say that Congress may make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. Concluding, the court said, the founders of this nation entrusted the lawmaking power to the Congress alone in both good and bad times. It would do no good to recall the historical events, the fears of power, and the hopes for freedom that lay behind their choice. Such a review would but confirm our holding that this seizure cannot stand. So, that court's opinion was clear. The president has no authority to do that which is not within his constitutional authority and not within the authority of statutes that Congress has given him power to do. We could learn much from that in the context of executive actions today, but that's not even the part of the opinion that the Supreme Court majority in the immunity case was relying on. In fact, it would seem impossible that they could have relied on that. Instead, they were relying on a concurring opinion, the opinion from Justice Robert Jackson. And this is an opinion that has gone down in history in national security circles and constitutional law circles as an opinion that most explains the president's power. It explains when the president's powers are at its highest, which is when it either has explicit authority under the Constitution or Congress has given it explicit authority, and when they are at their lowest, and when they're in between, when there's a twilight zone where there's some power that Congress has and some power that the president has. Well, guess what? The part of the opinion the majority relied on was actually the part where Justice Jackson was talking about the president's power being at its lowest. Here's what Justice Jackson wrote. When the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb, for then he can rely only upon his own constitutional powers minus any constitutional powers of Congress over the matter. Courts can sustain exclusive presidential control in such a case only by disabling the Congress from acting upon the subject. Presidential claim to a power at once so, here are the words, conclusive and preclusive, must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. The expansive reading of core constitutional powers apparently adopted by the majority in the immunity case is impossible to square with Justice Jackson's caution in this area. Yes, the president has constitutional authority to take care that the laws be faithfully executed, but the president's power must necessarily be limited by Congress's powers to enact the very laws the president is tasked with executing. In the immunity case, it was criminal laws. In another case, it could be any law. Despite the careful equilibrium Justice Jackson talked about as established by the Constitution, according to the Supreme Court immunity the Supreme Court majority in the immunity case, the immunity granted to the president was necessary to make sure that he could be energetic and vigorous in exercising presidential powers and not enfeebled by the prospect of criminal prosecution. The result was to elevate one branch, the executive branch, over the other two equal branches. So at that time when I was testifying last September, I warned of some potential consequences of this. I asked questions like this. If the president's authority is conclusive and preclusive, is Congress now disabled from tying the appropriation of funds to certain policy priorities or from enacting legislation that governs departments and agencies? As I've already mentioned, this president is doing both of those things. I asked, by disabling Congress from using its Article 1 powers and the courts from reviewing the president's conduct involving his own discussions with his Department of Justice, even ordering sham investigations, does that mean the president can direct the investigation of political enemies, of journalists, of activists, even when there's no basis for doing so? And look at what is happening right now. A week and a half ago, I'm not even sure it's been that long, the president fired his own chosen interim United States attorney in the Eastern District of Virginia because that U.S. attorney, a seasoned prosecutor, said there was not enough evidence to prosecute James Comey, the former FBI director and the president's declared political enemy. The president fired him, then directed his attorney general to work with his chosen replacement for that U.S. attorney, a person with zero prosecutorial experience, a person who had been an insurance lawyer, but who was part of the president's team at the White House. He told his attorney general, you need to work with her, and you guys need to hurry up and bring this prosecution before the statute of limitation runs. And just days later, literally between the Monday that she got there, by Thursday she had gone into the grand jury and she had gotten an indictment against James Comey. Even though The memos within that office, it has been reported by career prosecutors, people who have spent decades there, had concluded the evidence was insufficient for a prosecution. Now, a little aside here, you might say, well, if it's insufficient, how'd she get an indictment? A grand jury must have voted to indict. And you're right, but the standard is very different for a grand jury indictment. The standard for a grand jury indictment is probable cause that a crime has been committed. And I will note, the prosecutor took 3 counts to the grand jury. They did not have enough votes for one of them. The other 2 votes were only 14 out of 23 people. You have to have 12, and they eked out 14. But even if you think, okay, there's nothing wrong with that, the standard that governs a prosecutor, which I was for more than 2 decades, before you go into grand jury, you don't have to just think you have evidence, admissible evidence, to prove every element of the crime by probable cause. That's your standard for an indictment. You have to believe you have admissible evidence to prove every element of the crime beyond a reasonable doubt, which is going to be the government's burden at trial. And that's where the prosecutors in the office, including the one fired by the president, said, there's not enough here, right? There's not enough here. But now we have an indictment against someone that is the president's declared political enemy and someone that the president directed his Department of Justice to prosecute. And he has now said there will be more. The president has also used executive power, and those in his cabinet have used their executive power to coerce media organizations to cancel shows, fire journalists. The president is also now accusing nonprofit organizations of engaging in terrorism based on protected speech with which he disagrees, threatening criminal investigations and loss of tax-exempt status. What might have seemed hyperbolic to some a year ago now threatens the separation of powers that is fundamental to the rule of law, a system of laws by which both the governed and the government agree to abide. So let's move to the next pillar. Transparency in the enactment and enforcement of the laws so that there's predictability and stability. So we must ask, is there transparency in the enactment of the law when there has been ample reporting that members of Congress have been targeted for retaliation, including being primaried if they don't vote for the president's proposed legislation? Or when members of Congress say that they fear for the safety of themselves or their families because they've gotten death threats against them if they go against the president's wishes? Is there transparency and predictability and stability when prosecutors and FBI officials are fired because they investigated and prosecuted January 6 defendants? Or where others are hired as long as they publicly support the president's view that the 2020 election was stolen and that January 6th was a peaceful protest? Is there transparency, predictability, and stability when the president directs the prosecution of political enemies, as we've just discussed, while his Department of Justice shuts down an investigation into his political ally, border czar Tom Homan, who was reportedly recorded accepting $50,000 in cash from undercover FBI agents last September in return for agreeing to facilitate future contracts for borders related to border enforcement should Donald Trump win the presidency. That investigation squashed, the other investigations producing indictments. Is there transparency, predictability, and stability when the Department of Education targets universities for investigations based on failing to do enough to prevent anti-Semitism on campus, while also directing universities to end DEI programs or risk terminating grant funding? Is there transparency, predictability, and stability when the president blacklists law firms for representing his perceived political opponents or for litigating in opposition to his priorities or for hiring lawyers who had been involved in investigations of him before he was elected, while withholding such treatment from law firms that agree to change their hiring practices, get rid of DEI programs, and provide millions of dollars in pro bono, that means free legal services, to causes that the president supports? I could go on, but I'm sure you get the picture. There may be transparency, But the only predictability and stability that we can take from these actions is that those who challenge this president will be punished, while those who subjugate themselves will not. And that's another pillar of the rule of law eroded. The third, fair legal system by which rights and responsibilities are evenly adjudicated. Our courts are opening, they are functioning. But this is where the blacklisting of law firms may be even more damaging to the rule of law. And if you're not familiar with what I'm talking about, the president, through executive orders, stripped attorneys at 4 different law firms of their security clearances, ordered federal agencies not to do business with any company that was doing business with any of the blacklisted law firms, and even limited access of lawyers from those law firms into government buildings and to having conversations with government attorneys. Now, law firms often represent individuals and companies who have business with the federal government. So the upshot of these blacklisting executive orders were to shut down those law firms, and to shut them down because of the people they had hired, the causes they had litigated, and things that he disagreed with politically. So why is this so dangerous to the rule of law? Well, the adversarial process is the cornerstone of America's legal system. Judges preside over civil and criminal cases. They depend on lawyers to represent the parties before them, and that means both sides. The constitutional right to counsel is so fundamental that in criminal cases, if a person can't afford a lawyer is provided for that person at no charge. Lawyers provide ethical representation not only to people in causes that have popular approval, but also to those who do not. And in this way, lawyers on opposite sides of a case advocate for their clients, both by presenting the facts through evidence and making legal arguments based on those facts. That's due process of law. That's the stuff we've been talking about. It's the constitutional entitlement to have rights and responsibilities, individual rights and responsibilities, adjudicated by competent independent judges. By having both sides of the dispute presented in court, judges are better able to assess the merits and render informed judgments. Indeed, Donald Trump has been a huge beneficiary of this adversarial system. In civil and criminal cases, he's relied on competent lawyers to represent him. In his personal capacity, defending him against civil charges of sexual assault and defamation, or against criminal charges of mishandling classified information or conspiring to overturn the results of the 2020 election. Some of these things may have seemed unpalatable to some Americans, but it was the duty of lawyers in those cases to provide him with effective representation, and they did. Sometimes he prevailed, sometimes he did not, but there is no question he received due process of law. That is why the central importance of this, every one of those blacklisted law firms, every one of them ran into court, sought an injunction against those executive orders, and every one of them won. And 3 out of the 4 won the very same day they filed their lawsuit. The other one the very next day, because that's how critical it was. Judges understood immediately how unconstitutional these retaliatory actions were and how irreparably harmful they were to the rule of the law, not just to those lawyers and law firms in front of them, but to the rule of law. One judge wrote, "Our justice system is based on the fundamental belief that justice works best when all parties have zealous advocates, when all sides have vigorous representation and can present for the court to hear powerful statements on both sides of these questions." But even with these rulings in support of the law firms and against this blacklisting, there's been lasting damage. Law firms have declined to take on pro bono cases that challenge executive action, have declined to represent individuals targeted by the federal government because they are scared. They are scared of retaliation. When there are no lawyers to represent the opposition to the administration's executive overreach, we have no adversarial system, we have no due process, and we have no rule of law. Finally, the 4th pillar, diverse, competent, independent lawyers and judges. Despite historic efforts by lower court judges to uphold the rule of law, executive actions are making that more and more difficult every day, and they are changing the face of the judiciary and the lawyers who represent the government in court. The administration has sued an entire court of judges in Maryland, every judge on the bench, because they required the government to wait 48 hours after someone files a legal case before they deport that person. 48 hours for the judge to have a hearing and make a ruling. It has filed ethics complaints against judges who rule against it. The president has installed his personal criminal defense team from when he was not president at the leadership of the Department of Justice, and has elevated one of them to a federal circuit court judgeship. The administration has fired competent DOJ attorneys and replaced them with attorneys to lead a weaponization task force that is tasked with investigating and potentially prosecuting those who did their jobs and investigated and prosecuted those who attacked Congress on January 6th, those who and attempted to prevent the peaceful transfer of power. This includes even members of Congress that he has directed to be investigated. It has caused DOJ attorneys to misrepresent the facts in court, including about the removal of Venezuelans to a foreign prison without due process, and including about the attempted removal of unaccompanied minors who fled trafficking and abuse in their home countries under the guise of family reunification, where neither the parent or the children had requested it. In fact, this is another case my organization is handling. The government actually had to retract the representations it made to the court on Labor Day weekend that every child on that plane that was going to be spirited out of the country, every child's parents had requested their return. Upon further investigation, the judge who later ruled, the government had to retract that because it turns out not one of those parents had requested the return of those children. Not one. The administration has fired the top judge advocates general of the Army, Navy, and Air Force. And if you don't know what that term means, that means the top lawyers for the Army, Navy, and Air Force. Because, in the words of the Secretary of Defense, he didn't want them to pose any, and this is a quote, roadblocks to orders that are given by the commander-in-chief. In other words, we don't want the advice of the lawyers. The administration doesn't want to be told that its plans might be illegal. Those plans might have included lethally striking boats in international waters, allegedly transporting drug cartel members and drugs with no legal authority. Those plans might have been to send military into our cities for general crime fighting in violation of the 10th Amendment and in violation of a congressionally enacted statute, the Posse Comitatus Act, that prevents the military from engaging in domestic law enforcement. But it's not something potentially that the Secretary of Defense or the President wanted to hear, did not want to hear from the lawyers. You know, there's a famous quote from a play. The first thing we do, let's kill all the lawyers. We're not to that yet. Let's hope we don't get there. It doesn't take a lawyer to see how dangerous this is. The President has openly praised Supreme Court justices who rule in his favor while attacking those who vote against him. On the Supreme Court's emergency docket, where the President has repeatedly asked the Supreme Court to intervene when a lower court stops something that he has done, they have usually be concluding it was in violation of the separation of powers. The President's appointees have now ruled in his favor several times. Cases on the emergency docket are not fully briefed. There's no oral argument. The justices sometimes don't even have the opportunity to discuss the cases in conference because they are on the emergency docket. Ordinarily, it would be very difficult to meet the standard that the Supreme Court sets to intervene on the emergency docket because it's so highly expedited. But this year, the number of rulings with enormous ramifications have been off the charts. Justices appointed by the President and a few others have intervened on several occasions, often with almost no explanation given. Now, many of these interventions have been in cases that have involved the dismantling of departments and agencies, the refusal to spend funds appropriated by Congress. Just last week, the Supreme Court intervened and blocked a ruling that would have required the President to spend funds for foreign aid that Congress had directed to be spent and had to be spent by tomorrow, September 30th. That emergency ruling is a final ruling, right? Because once those funds are not expended by tomorrow, it doesn't matter if ultimately the challengers win in a year from now in the Supreme Court on the merits, the money did not get spent. Many of these interventions have been on procedural or technical grounds, not on the merits, meaning that the core legal questions have remained unresolved, but the damage is done. It provides little transparency, predictability, or stability, and it has led to deep distrust of the Supreme Court that is supposed to be politically independent. And it has arguably emboldened this president to be even more aggressive. So as we think about the rule of law, we might think back again to what Professor Zambrano described, to the view of those in post-authoritarian regimes that the rule of law is what stands between democracy and dictatorship, to the reasons why we must have institutional stability achieved through these pillars of the rule of law to prevent authoritarian rule, to prevent the executive branch from eclipsing the two other equal branches of government, and to enable us as individuals to have due process of law. And that is why I want to end on a positive note. I know you're thinking, oh God, really, will she finally? I spend much of my days as a litigator. My team at ICAP has challenged many of the overreaching executive actions that we've talked about. I told you we won a nationwide class action stopping the birthright citizenship order. We won a preliminary injunction stopping the president from removing, not the president personally, but his Department of Homeland Security from removing unaccompanied minors without any type of due process, and other cases. Other lawyers at nonprofits, state's attorney general, and lawyers at firms who are not yet totally cowed by the president's blacklisting are doing the same, and we are overwhelmingly winning, at least in the lower courts. But that is nowhere near enough. Americans cannot afford to look at each executive action individually and maybe dismiss it as inconsequential or not worth their time because it doesn't impact them personally. We must look collectively at what is happening, at the actions that violate the text of the Constitution, the separation of powers, and fundamental rights like due process. Eventually, these actions will harm all of us, and we just can't wait too long to see the path we're on. If the message is spread about the rule of law and what it means through events like this one tonight, through organizing and mobilizing the power of people's voices in your communities, through calling your Congress members and demand that they do something, through getting out the vote, for running for election yourselves, we can collectively stop the erosion of the rule of law. It won't be overnight, but it can be done. It has happened in other countries. And if we are complacent and we think that America is too exceptional to go down the path of other countries, we are wrong. We must make our voices and our votes heard. And I think by you even being here tonight shows that you care. Thank you for inviting me. Thank you for your time.
Professor McCord, thank you very much. I know you've already given us a lot to think about. Just a reminder, everyone, to please submit your questions for Professor McCord with the QR code. And we also do have note cards for those who don't want to use the QR code. You can see a Hughes Center fellow up at the front of the room, and we'll make sure that those questions make their way here as well. Give me one moment to pull up our questions.
Yeah, that's fine. Stunned silence. Nobody.
My
nobody's
laptop
gonna
is
say.
thinking
I have
about
that
it.
impact on people.
Thinking long and hard. I'm sure it's going to pop up.
I can be fun sometimes. I really can. But I shouldn't make too light. I mean, it's a serious time and requires a serious response.
Okay, here we go. Okay. Some commentators have questioned whether the president will comply with decisions by the U.S. Supreme Court. What remedies are available under the Constitution or other federal laws to enforce decisions by the U.S. Supreme Court if the president ignores those decisions?
So pretty famously, it has been said that, the president has no army, and it is true. I mean, excuse me, the president does have an army. The Supreme Court has no army, and it is true. The reason that there has been compliance generally with the rulings of the Supreme Court throughout her history goes back to what I talked about at the beginning, right? The respect of the branches for the other equal branches and the desire to maintain our institutional stability, maintain our democracy. And part of that means you comply with what the Supreme Court says, no matter how much you might disagree with it. And certainly this president, if there are rulings he disagrees with, and I expect there have been some already, and I expect there will be quite a few more, he might disagree. But historically, there's been compliance. So there is not a mechanism. Certainly, you can hold someone in contempt. You can hold the executive branch in contempt, fine the executive branch, sometimes even have an executive branch official go to jail. But of course, this president is immune from criminal prosecution for his official acts, so that wouldn't work for the president. But we really have to hope that the president and those around him will respect the rulings of the Supreme Court. And I do have a little bit of hope there, because his attorney, John Sauer, actually during the argument on the scope of the birthright citizenship injunctions, because that case has already been to the Supreme Court once, it wasn't on the merits of his reinterpreting the 14th Amendment, it was solely on whether lower courts can issue an injunction across the entire country instead of just in individual places. And at that time, the Solicitor General of the United States, John Sauer, did say to the Supreme Court, when asked, that the government would abide by the Supreme Court's rulings. He did not necessarily promise to abide by lower court rulings, which is a fairly shocking thing in and of itself, but he did say they would abide by the Supreme Court. Now, John Sauer is not going to be the decision maker on this, but certainly we know that at least the president's chosen Solicitor General, who was one of who was the attorney who argued the immunity case for the president, is committing to that compliance, and would have the president's ear.
Thank you. Next question. Where do you see our country heading in the future? Do you think the next or future executives will agree to legislation that limits their powers in the future? Do you think it is possible to recreate equilibrium among the three government branches?
I definitely think it's possible. I think we first need this Congress to be acting. And if that's not going to happen, we've got elections coming up in 2026. These are critical. If you think they've been too silent, if you think they've been too complacent, they haven't exercised their powers, and this really doesn't matter what your politics are, right? No matter whether you're a Democrat, an independent, a Republican, there are plenty of things here right now that should be causing you some concern. And it's time to have elected representatives who are going to actually do their job. They have authorities right now that they are just ignoring. And so I think that, whether we are going to get to that point, right, of having the equilibrium that the Constitution sets forth, that was always intended by the founders, means we have to demand that of our elected officials. If the elected officials are just going to kowtow to the president, we've just lost an entire branch of government. And again, I would say, and I'm not always a fan of Congress, it is the first article. It's the article before the article that creates the executive, for goodness sakes. I mean, you do put some things number one. So I think it's really 2026 is big. And also, can I just say about that? That is also why having a free and fair election that is not infected by political violence is so important. That means support your local election officials, right? These are nonpartisan people who are doing their jobs to try to make sure everyone who has a right to vote can vote safely. There are law enforcement who help to also protect people's right to vote. I mean, these are things we really need to stand up for. And none of the shenanigans to try to suppress the vote, like free access for those who have a right to vote. These attacks right now on mail-in voting, on early voting, these are all attacks on Americans' ability to go exercise the franchise. Threats against election officials who won't say there's fraud in an election. We've seen that in the last few elections. Threats against election officials who, refuse to who actually refuse to certify an election. These are things that really impact the free, fair elections that we rely on. And the only way we're going to make change is if we protect our elections.
Can you discuss the legislature's abdication of responsibility in crafting law and handing it over to the executive and judicial branch, specifically the more recent trend in tribalism and extremism of the parties, which prevents compromise legislation, both from legislators themselves as well as a very tribal populace?
So that is a great question that I don't think I'm really qualified to answer, because that's really more like we need a sociologist and a psychologist or something to answer that. Like, I don't understand it. You know, when people run for election, I mean, there's a certain amount of like, you know, desire to want to do this thing you're elected to do, and to represent the people you represent, and to advocate for the policies you agree with. But what we seem to be seeing in recent years, and particularly in this particular administration, is legislators who are cowing, and you know, part of it is because of political violence, like I talked about a few minutes ago. We know, for example, with budget reconciliation legislation and other things like that, you know, there were members of Congress who said that they ultimately caved and voted, and they didn't say this super publicly, but they said it to reporters who reported on it because they were afraid. They were afraid not just that they might get primaried and lose their election, but they're afraid because when the president speaks ill about them in social media, they get death threats. Their children get death threats. Their children get followed home from school. And at bottom, we had legislators who said, you know, this impacts me. Look how many are now resigning, right? And they're saying partly it's because they're threatened. So, you know, I think we can't discount the impact of that pressure on them. On the other hand, this is their job to do, and this is, you know, they have Article 1. They have authorities, and it boggles the mind at the unwillingness to use those authorities, especially if you care about the country and not just your tribe.
What advice can you give to students who may struggle with knowing which side of the political debate to believe? For example, how can we objectively evaluate executive overreach?
So I think you can, I really do think you can take politics out of this. It's a hard keynote to give because it's going to almost necessarily have a political valence, which is why I tried to center almost everything I said on the terms of the Constitution, you know, its provisions, and actual words that the Supreme Court has spoken. Because then it's not Mary McCord on the Constitution, it's the Constitution on the Constitution and the Supreme Court on the Constitution. And regardless of what policies you might like or dislike, regardless of whether you're conservative or liberal, whatever those terms mean anymore, and I think there's quite a mishmash about what those terms mean, you know, you can look objectively and say, Article 1 says Congress has the power of the purse. They have the power to appropriate funds. Article 2 says the president has a duty to take care that the laws be faithfully executed. I can put these two things together. That means when Congress creates a program and funds it, the president's job is to then execute on that through his executive branch. That doesn't have to be political. So I think as students, this has got to be a confusing time, to be honest, to be in university. I can't really even imagine what it would be like trying to figure out where things lie. Cut out the noise. Don't get your news from social media, please, I beg you, and go back to original sources. I mean, for me, I was a journalism major before I was a lawyer, and every single thing I read, I want to know, what's the source? Is that source credible? And should I trust that source? And I think we take way too many things from just mouthpieces saying words that cannot source it in real, credible, you know, origins. And so, be a student of everything that you listen to and track down the source.
Thank you. Do you believe we are in a constitutional crisis? If not, do you believe we are heading towards one?
You know, there are so many red lines that we could call constitutional crises, and I think we've tripped a bunch of them, honestly, and different people have different tolerance. And I think for me, I have often thought that so long as the government is still going in court and defending, making legal arguments, they might be weak in some cases, but making legal arguments in front of a court and engaging in that adversarial process, that we still have a basis for rule of law. In other words, they're doing that rather than saying, I'm not even gonna show up because I can just do what I want, right? Like, they're still engaging in the process. All of that said, we're seeing so many abuses of the process. I've already indicated some just flat out misrepresentations made to court by government attorneys, firing of government attorneys who were ethical. You know, this firing of Eric Siebert is not the first time that somebody has been fired, and we've had attorneys leaving because they don't feel like they can ethically go into court and represent the government. So, and we have had some what do appear to just be defiance of court orders, particularly when we talk about those planes going to El Salvador with Venezuelans on them. So I think there are many people that would say we've already crossed it. I still hold out hope. I will say, though, particularly, and maybe this is because of my history as a prosecutor, that what happened this week with the indictment of a political enemy, right after the president directed that enemy be indicted, and in the face of career prosecutors saying there's insufficient evidence, to me that was really crossing a Rubicon that I think it's going to be hard to recover from. But all that said, positive, we can recover. Elections, we can do it. Yes.
What effect does the current Supreme Court's willingness to overrule or ignore precedent play in the erosion of the rule of law?
Well, you know, I mean, this comes back to those pillars that have to do with this diverse and competent and independent judges and a fair system for adjudicating rights and responsibilities, because I do worry that Americans are losing faith in the Supreme Court. And, you know, some people may approve of some of what they're doing, but they can't possibly approve of the way they're doing it. Even if you like a result as a matter of policy, does it really make sense for there to be no explanation? And especially when you're creating a result on an emergencies docket that is directly contrary to your own precedent. I mean, this case about Lisa Cook, the Federal Reserve Board, you know, Humphrey's executor 90 years ago said that presidents can be restrained from firing members of a multi-member bipartisan board. And, you know, you would think that unless and until they actually overrule that after a fully briefed and argued case, that they would stick by their law. Yet, time and time again, they have allowed the president on the emergency docket to fire the member of the bipartisan board. Once that person is fired, she may win in a year, but the person has been fired and the board has gone on without that person. And so that, I think, is very, very damaging. They're not even following their own precedents on the emergency docket.
Thank you. Okay, this one's a long one.
Oh my.
Can you discuss the historical slope of executive overreach, especially in the context of distrust of existing institutions? It seems reasonable to say the current chaos exists because both past executives have sought to expand their power for decades, and a sizable minority of the population is neutral to the current overreach because they do not trust the institutions the president is undermining.
So there are people who study just this that would be better equipped to give a fulsome response than I can. But it is definitely true. This is not the first president who's ever tried to sort of push his authority through executive orders, right? And sometimes this is out of frustration when they can't get their policies through Congress, and so they will consult, you know, within their own administration, with the lawyers in their administration about, well, what could we lawfully do through executive order? What can I do that doesn't require a congressional statute? And, you know, presidents rely on the Office of Legal Counsel. It's a group of lawyers within the Department of Justice to give advice about things like this. They have done that for a very long time, and if it's a national security matter, they rely not only on the lawyers in the Office of Legal Counsel and also the lawyers in the National Security Council, but also lawyers at all of the intelligence community agencies and national security agencies. And so, even though sometimes courts have found that some other executive actions have been overreaching, and certainly we've had abusive things in the past, I have never questioned whether the presidents weren't doing things in modern history, let's just keep this post-Watergate, I've never questioned whether the presidents were at least getting the legal advice and taking it into consideration. And maybe they misstepped sometimes, maybe they overreached, but here, I don't know that they're even asking the lawyers for advice. And I know that for a couple of reasons. One, I told you about with respect to the Defense Department, just have fired the top lawyers, and very blatantly, we don't want any roadblocks. But some things are happening so fast. I mean, I was in the Department of Justice for almost 25 years. Office of Legal Counsel moves really slow, like really slow. As prosecutors, like we can be a little quicker, like they are gonna ponder this issue of executive authority and they're gonna ponder it, and they're gonna exchange a gazillion memos, and then they're gonna brief this up to the president, and then he's gonna get other legal counsel, and sometimes that's why things take a long time. The pace, the sheer pace of executive actions in these last 8 months defies the possibility that the legality of the things that are happening could have gotten actual real scrutiny. And I think that's a scary thing that makes this different than in the past.
In your view, what is the biggest emerging threat to U.S. national security over the next decade that most people are not paying attention to?
Wow, how long do we have? So I think, I'm just going to say a couple of things. And one is that maybe the most important for me is turning all of this attention right now to our domestic situation and calling things that are just regular crime terrorism. Now, I will tell you, I have written extensively about domestic terrorism. I teach about domestic terrorism. Domestic terrorism is a serious threat to our national security. And by domestic, I mean it's not motivated by ISIS or Al-Qaeda or Boko Haram. It's motivated by what we think of as domestic ideologies. They're not really domestic. It can be racial or ethnically motivated violence. It can be anti-government and militia extremism. It can be environmental extremism. The lethality of domestic terrorism has been greater generally over history than the lethality here in the United States of international terrorism, putting aside 9/11, obviously. It is a serious issue, but that when we're talking about that kind of terrorism, we're talking about crimes of violence in violation of state or federal law that are done to intimidate or coerce a civilian population or affect the policy of government through intimidation or coercion. We are not talking about graffiti. We're not talking about, trespassing. We're not talking about speech that might be anti-fascist or anti-whatever. And right now the danger is that so many things are getting labeled by this president as domestic terrorism. So many resources are now being thrown at this, in part conjured up problem, including our military resources, massive law enforcement resources, totally, ICE expanding, FBI agents leaving by the droves because they're being pushed out because of the cases they've investigated in the past. These are the people with the experience, with the counterterrorism and the counterintelligence experience, people in our intelligence community getting pushed out because of the opinions they gave about Russia's effort to involve themselves in our election in 2020. They're leaving, or they're being fired, or they've had their security clearances stripped. You obviously can't be an intelligence professional if you don't have a security clearance. So what are we now going to be left with when it comes to the international threat? Because we have adversaries out there in multiple countries. And I'm not just talking about foreign terrorist organizations, but by the way, they're not like on vacation right now. They're still using this time to regroup and plan and plot, because we are still their enemy. But we also have adversarial nation states, right? Russia, North Korea, Iran, China. Love all the people in these places, but as a nation state, their interests are adversarial to us. And this is a gift to them, in my opinion, that we have a president who is so focused on vilifying his own constituents that everybody else has got time to plot and plan. And I'm wondering, are there enough people who are tracking that? Now, I know plenty of intelligence professionals who are still in the intelligence community who are working day and night on this, but it makes me very nervous.
While the president has immunity for his actions, can those who are following the orders of the president be held accountable for illegal action? For example, can the heads of executive agencies that carry out illegal actions ordered by the president be prosecuted, or can he just pardon them for their actions?
Yeah, so this is a great question. This is also something, I talked a little bit about when I testified about the immunity decision before the Senate. And one of the other questions I raised is, this decision is just about the president. But suppose that one of the, members of the executive branch is doing something because the president told him to do it. Are they going to be able to go into court if they do something that is blatantly unlawful and criminal and say, his official immunity really ought to extend to me because he made me do it? Because at what point, when does that stop? And then have we immunized the entire government from prosecution for corruption? Because we're talking about then the ability to be as corrupt as possible without any accountability. We don't know the answer to that question, and I would hope that many people would just refuse to violate the law. I mean, we have seen prosecutors quit and Department of Justice attorneys quit because they refuse to violate the law or take positions that they think are in violation of law. But there's lots of other agencies too, and we've seen people quit in those places too. And so we don't yet know the answer for that because it hasn't really been tested yet in court. Like, we haven't had a situation of a prosecution of somebody in those circumstances. But that's where the very end of that question comes into play, because if we're talking about a federal crime, we could see a president saying, I want you to do X, and if you're prosecuted, I'll pardon you. So it's a bad situation. So this is when we need to appeal to people's actually sense of right and wrong, and that we are, right, a system of laws by which both the governed and the government agree to abide.
It's time for the last question, so we're going to end with a positive one. Yes. How do you stay hopeful and persistent when facing such complex and divisive issues, especially in times like this where we are so divided as a country?
Maybe I should ask my husband to answer that one. Do I stay hopeful? You what? Yes, he's actually right about that. I try to get out when I can and get in nature. And I try to do something about it, right? I mean, I think that we all are motivated by different things, but I'm here to urge people to be active. Going hiking and touching grass, I mean, definitely helps to get my head straight. Going for a run, that is literally my mental health. But the way we can feel like we are doing something, I think, can give people a little bit like, I'm trying, I'm doing my best. I'll tell you, I teach a practicum seminar at Georgetown where we have students in the law school who can participate in some of our work at ICAP. And I felt bad for the ones this spring because so many of the cases are so profound and so important, and what was happening in the country so frankly just depressing for like a young law student who's excited to be going out and practicing law. And every one of them said, actually, this makes me feel so much better because rather than just sitting by the sideline and reading the paper about what's happening, I felt like I was doing something. So everybody can do something. You don't have to be a lawyer. We've talked about what you can do. Mobilize, vote, protect the vote, run for election. It's a great idea.
Professor McCord, thank you. Thank you for celebrating Constitution Day with us. Thank you for sharing your time and expertise with us. We appreciate you.
Thank you, Sarah, for facilitating that conversation, and thank you again to Professor McCord for sharing her expertise with us. We ended on a great note, I think, with that positive message of the things that we can do to stay active, stay engaged, make sure to exercise your right to vote. For more info about the work of the Hughes Center and more events like this, I just want to encourage you all to take a look at our website, stockton.edu/Hughes Center. Follow us on socials to stay up to date about events like this, and we hope to see you at the next one. Good evening. Take care.